Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning because you have a case in this court. The case that you have is classified as a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your more serious type criminal offenses. The misdemeanor cases are normally referred as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. If you were charged with a felonies are divided into 5 categories. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If you're convicted of a state jail felony, the range of punishment is a minimum of 6 months to a maximum of 2 years in the state jail and a fine up to $10,000. If you are convicted of a third-degree felony, the range of punishment is a minimum of 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment is a minimum of 2 years to a maximum of 20 years and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is a minimum of 5 years to a maximum of 99 years to life in the state penitentiary and a fine up to $10,000. Now, if you're convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary or death by lethal injection. Now, the case that you have here is not a felony. You have a misdemeanor case. And in this court, your misdemeanor cases are divided into 3 categories. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If you're convicted of a Class C misdemeanor, the range of punishment is a fine only. You cannot be given jail time as the range of punishment. It's only a fine. Now, the Class C misdemeanor cases get to this court only when they are appealed from the city court or the JP court. So the Class C misdemeanors are normally handled in the JP court or the city court, but when they are appealed, when a person files an appeal, he wants a new trial, then the case comes up to this court, and then this court has jurisdiction to handle that case, and the range of punishment is still the same, a fine only. If you're convicted of a Class B misdemeanor, the range of punishment is a minimum of 0 days to a maximum of 180 days in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is the right to have an attorney to represent you. The documents on the clipboard, the first document should read Judge's Explanation of Rights to Defendants Without Attorney. And I will go over this document with you. And it reads, as a defendant in a criminal case, you have 3 options. That's regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number 3, you may represent yourself. If you want an attorney to represent you and have enough money, and you have enough money to hire an attorney, the case will be reset. Reset means you'll be given another court date. So the case will be reset to give you time to hire your attorney. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to waive or give up your right to have an attorney, if you want to represent yourself, the next paragraph states, you may not speak to the prosecutor. The prosecutor is the assistant district attorney. We have one sitting here at that table in front of you. He works with the Jefferson County District Attorney's Office. So you cannot speak to him about your case unless you sign a written waiver of your right to be represented by an attorney. And that's what the second page is. The waiver is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, the next paragraph states, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of this document, it states defendant's choice. Defendant's choice, mark initials next to only one choice. Now, if your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney or counsel to represent you, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if your choice is, I want to waive my right, that means I want to give up my right to an attorney and represent myself, then you will put your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that's titled defendant, and you will place today's date, which is February 14th of 2023, on the line that is titled date. Now, for those of you who will be waiving your right to an attorney and you're desiring to represent yourself, you'd have to read and sign the next document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads as follows. I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 14th day of February of 2023 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel, or I hereby give up my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, February 14th of 2023. Now, as a defendant in a criminal case, you have other rights. One other right that you have is a right to have a trial by jury. Where that gentleman is sitting in that area over there, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your case, and they will decide whether or not you're guilty or not guilty after listening to all the evidence. You also have a right to waive your right to have a trial by jury. That is, you have a right to not have a trial by jury if you choose to. And if you choose not to have a right, if you choose to not have a trial by jury, then your case will still come before the court, but it will come before the court in one of 3 ways. One way it can come before the court is by way of a trial, by way of we call it a bench trial. That is a trial by judge only. The judge will listen to the evidence, and after listening to all of the evidence, the judge will decide whether or not you're guilty or not guilty. You also have a right to waive or give up your right to have a trial by judge or a bench trial. And by doing so, your case will come before the judge by way of either an agreed plea bargain or an unagreed plea bargain. Now, a plea bargain is basically an agreement that you have reached with the state or with the prosecutor to settle your case. And if you have not reached a plea bargain agreement with the state, we call that an unagreed plea bargain. In essence, your case will come before the court, and the court will decide what your punishment will be. Now, if you have reached an agreement or plea bargain agreement with the state, we call that an agreed plea bargain. Now, if you have an agreed plea bargain, your case will come before that's the 3rd way it will come before the court. And then the court can either follow the plea bargain agreement, either accept it or reject it. Okay. So if the court rejects the plea bargain agreement, then you have a right to withdraw or take back your plea. For example, when I use the word plea, actually you can enter one of 3 types of pleas. You can enter a plea of not guilty. And if you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. And if you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. So if you have a plea bargain agreement and you enter a plea of guilty or no contest, and the court can accept or reject the plea. If the court rejects your plea, then you can take back, or if the court rejects your plea bargain agreement, then you could take back your plea of either no contest or guilty. Now, if the judge follows if the judge go along with the plea bargain agreement or follows the plea bargain agreement, then if you would like to appeal your case, then you would have to, and what appeal is, you would like a higher court than this court to review your case to see, one, whether or not you've been wrongfully convicted or whether or not the court has committed an error by convicting you. And in that case, then if that's the case, then your case will be reviewed by the 9th Court of Appeals, which is right above us. They will review your case. They will decide whether or not you are guilty or innocent. Well, they would not guilty, innocent, but they would decide whether or not to accept, which means to grant your appeal or deny your appeal. If they grant your appeal, then they can find you. They could just simply acquit you and find you not guilty, and the case is over. Or they could send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than the 9th Court of Appeals. You could appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. Pro se means you would have to do it on your own without the assistance of an attorney, and you will file the pro se petition to the Texas Court of Criminal Appeals. They could either grant or deny your petition. If they grant your petition, they can simply find you not guilty. Or if they deny your petition, then, let me back up. If they grant your petition, they can find you not guilty, or they can send the case back down to this court, or to this court to give you a whole new trial. Or if they deny your appeal, then at that point, your conviction will stand. Now, just a recap, you have a right to have an attorney. You can either hire an attorney, you can see if you qualify for a court-appointed attorney, or you can waive your right to an attorney and represent yourself. You can, your case can come before the court. You can ask, you have a right to have a jury, have a trial by jury, or if you waive your right to have a trial by jury, you can have a trial by judge. We call that a bench trial. Or your case can come before the judge by way of an agreed plea bargain or an unagreed plea bargain. Now, you also have a right to have witnesses to come to court. Witnesses can testify for you or against you if you represent yourself, or if you have an attorney represent you. They can ask questions of the witness. We call that either direct examination or cross-examination. Now, you can waive or give up your right to have witnesses to come to court. Now, that simply means that you will not be calling witnesses. It does not mean that the state of Texas will not be calling witnesses, because they will be calling witnesses. Now, you also have a Fifth Amendment right against self-incrimination. And what that means is you have a right not to testify against yourself in your trial. A lot of times you hear referred to as, I take the fifth. And that basically means the person is saying that I'm not testifying in my case. Now, you can waive or give up your right against your Fifth Amendment right against self-incrimination. And if you waive or give up your Fifth Amendment right against self-incrimination, that simply means that you will be testifying in your case. Now, you also have a right to have what we call discovery. Discovery means you have a right to see the evidence that the state has against you. You have a right to see the documents, witness statements, instruments, videotapes, audio tapes, any evidence that they have against you. You have a right to have access to it. If you're represented by an attorney, your attorney will have access to that evidence. Now, you also have a right to waive or give up your right to discovery, which means that you do not want to have access to the evidence that the state has against you. You also, now, as a defendant in a criminal case, everyone that's here, you're here for arraignment. And as I mentioned earlier, arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Everyone that's here, you're here because you have been arrested on your case and you're out on bond. You're either out on a cash bond, which means that you paid the full amount of the bond to get out, or you're out on a surety bond, which means that you paid a bondsman a percentage of the bond, normally somewhere around 10%, to get out of jail, or you are out on a PR bond, which is a personal recognizance bond, which means you didn't have to pay any money to get out. You simply released under your own personal recognizance. You had a promise to appear. Now, every day that you spent in jail, that jail time can be used as credit towards your punishment. For example, let's say you spent 5 days in jail before you bonded out. Then, and let's say you've talked to the district attorney's office, and the district attorney has the DA basically is working out a plea bargain with you, and they're offering this for you to serve 5 days in jail. What that means is you won't have to serve any more time in jail, because the time that you spent in jail, you'll be given credit for that. You'll be given credit for the time that you've already served. Now, if you spend 5 days in jail, they're offering 7 days in jail. That means you have to serve 2 days in jail. Why? Because you've been given credit for the 5 days that you've already been served. Now, every day that you spent in jail will also be counted toward your fine and court costs. Every day that you spend in jail, it is credited as $100 per day that will go toward your fine and court costs. So if you spend 5 days in jail, that's $500. So if the state is offering you $500 the fine and court cost of $500, then you won't have to pay the fine of $500. Why? The fine and court cost of $500 because the time that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if they're offering fine and court costs of $700 and you spent 5 days in jail, that means that you would have to pay $200. And because you've been given credit for the $500. So you just take 500 from 700, that leaves 200. Now, you will be required to pay the $200 on the day of the plea. Now, if you cannot pay the fine on the day, the fine and court costs on the day of the plea, then what can happen is we could put you on a payment plan. Okay, you could be put on a payment plan where you could pay off the money over a period of time, so much a month. Now, let's say because of your financial situation, you still will not be able to pay the fine and court costs. Then if that's the case, then we can convert the fine and court costs to community service. And what that basically means is you'll be required to work at a nonprofit organization to do some community service. Now, every hour that you work a community service, $12.50 will go toward your fine and court costs. So if you work 8 hours of community service, that's $100 that will go toward your fine and court costs. Now, Jefferson County has a program that is called pretrial diversion. It's for first-time offenders. If you haven't been in trouble before, there's a program with Jefferson County, the district attorney's office will dismiss your case. And they'll put you into this program. And if you complete the program, you can get the case expunged from your record. Expunged means wiped off, deleted, or erased from your record. Now, in order to qualify for the program, you have to be a first-time offender. And then 2, you have to have an attorney to assist you to get into the program. And 3, it cannot be an offense involving resisting arrest or unlawfully carrying a weapon. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office has a program, part of the pretrial diversion program, that is called Veterans Court. You can get into the program, and then that program, you may be able to get it expunged from your record as well. Now, if you need any information on any one of those programs, we'll be happy to provide that information to you. And I think with the Veterans Program, I don't know if you have to be a first-time offender or not. I think the only criteria is that you have to be a veteran of any one of the branches of the United States military. So if you're interested in any one of those programs, just let us know, and then we'll be happy to give you the paperwork and point you in the right direction so that you can talk to the person or persons that you need to talk to. Now, this court, Jefferson County Court at Law Number 2, has a program that is called the CSI program. CSI stands for Community Safety Initiative. The program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to go to church. The way the program works is the program is designed to address the issue of what is called recidivism. Recidivism is where people commit crimes over and over. So how do we address the issue of recidivism? Well, is we address it through the Community Safety Initiative. And with that program, we have partnerships with local agencies. One of the agencies that we have a partnership with is our Spindletop Center, which is our local mental health center. And with the Spindletop Center, we have, they have counselors, mental health officers as well. They have a whole staff that can assist you. Now, what they'll do initially is do a private interview. And once you get a private interview, they could develop an assessment plan. They can do an assessment and then develop a treatment plan for either outpatient or inpatient treatment to treat your mental health needs. Now, you do not have to be incompetent or insane to qualify for the program that Spindletop have. If you have anxiety, depression, you might be bipolar, schizophrenia, you might be suffering from post-traumatic stress, or a whole host of other mental illnesses, they'll be able to address those illnesses and it be address the needs that you have. Now, if you have issues with drugs or alcohol, then Spindletop has a program that is called ATAR, and our local drug and alcohol counselor has a program that is called OZAR. And both programs, they will do a screening, they will do an assessment, and then they will develop a plan for either outpatient or inpatient treatment to address your drug or alcohol addictions. If you're unemployed and do not have a job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with the community, with CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a program that is ran through Lamar University. And that program is a job training program and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in any one of those areas that you select, they will assist you at getting a job in the area that you train in. Now, if you have not graduated from high school and you would like to get a GED, they also have a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I have just mentioned are free. It does not cost you anything. Only thing you have to do is be willing to get into one of these programs. These programs also can be used as community service towards your case. So for example, let's say you are in the mental health program with Spindletop. Every hour that you're in that program, 1 hour goes toward the program, another hour goes toward your community service, and $12.50 will go toward paying your fine and court costs. So you're doing one thing, but you're getting credit for three. I like to say that, you're killing 3 birds with 1 stone. Now, I tell people this all the time: when you come to county court at law number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And we're trying to make a difference in the community in which we live. And we believe that we can produce productive people with these programs, and productive people normally do not commit crimes because they have too much to lose. In this court, we do not just arrest the problem, we address the problem. That is, we don't just give time, we take our time. And so if you're interested in one of these programs, just let us know, and then we'll be happy to assist you at getting in the program. Now, we do have someone from Spindletop here. We have Deputy Hinton, who's a mental health officer. He's going to come before you and tell you something about the program that Spindletop has. Mr. Hinton, would you please come forward?
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a licensed mental health deputy and commissioned by the Sheriff's Department here. The reason I'm here is the judge has graciously allowed me in this courtroom because he cares about every single person that comes before his court. What the judge has found, what's specifically proved, is those who fear legal issues commonly have mental health, substance use disorders, or sometimes just a lack of community resources that can help you with your particular situation. Our goal here today is to get you out of the cycle of arrest. If it's like you, maybe it's your first time to be here, maybe it's your 10th time to be here, if you're still in hope. But it's going to require one thing from y'all, and it's you're going to have to be able to share that need with us. Here in a little while, when the court goes into recess, I'm going to pass this out to everyone. This is separate from the court documents. This will not be included in the court documents. This is private, it's regulated. Anything you put on here is just like a doctor document. It will not be shared with anyone outside your visit, but it'll give us an opportunity to help you, get you plugged into resources that would best fit your particular situation. Also, I want to give you this here. It's a little flyer, tells you a little bit about the program on the back, and on the front, it also has a 1-800 number. Should you ever find yourself in a safe place, you can call that number immediately. It also has an office number on here. You don't have to wait for me to call you, to text you, or however you choose to communicate with us. you can go ahead and call and we can prioritize you and move you up. If you want to speak today, the judges graciously gave us the opportunity to meet in the jury room. And we can visit one-on-one privately. Nothing will be exposed outside your commission again, but it's up to you if you want to do that. We can do that today. So when the court goes in the recess, I'll be passing this out to everyone, and I'll also get this in your hands for you to take with you. You'll put the necessary information I need to contact. Thank you very much. Thank you, Ron.
You're welcome, Deputy Henry. Now, ladies and gentlemen, the paperwork that you have, for those of you who will be requesting that an attorney be appointed to represent you, you should have a document that is titled Jefferson County Affidavit of Indigence. And on that form, you're going to be required to, on page 1, just fill it out in its entirety. It starts off, it says this portion to be completed by or with defendant. And it has your name, you put your name, your date of birth, your address, your phone numbers, all the numbers that you have, home, cell, work, family member. Or if you receive any type of governmental benefits, you're going to check any of the boxes that are appropriate. For example, if you get Medicaid, SSI, SNAP, TANF for public housing, you'll just check the box that's appropriate. And when it says, are you employed? If you are, yes. If not, no. And then if you are employed, you'll put where and the type of work, and then the number of hours. The next line is number of hours, how long you worked at that job, and your marital status. If you're single, married, divorced, widowed, or separated, you'll check the appropriate box. Now, at the bottom, the next line where it says name of spouse, that is, if you're married, you're gonna put your spouse's name. And below that, it has name of dependents. You have any children at 18 years old or younger, you're gonna place their name and their ages in the appropriate box. On the residence information, it asks whether or not you rent, own, reside with a family member, or homeless. Whatever is appropriate, then you're going to circle the category that is appropriate. So for example, if you own a home, you're gonna put yes. If you don't own it, it'd be no. If you rent a home, yes. If you don't, no. You reside with a family member, yes. If you don't, no. If you're homeless, yes. If you're not homeless, no. And then under monthly income and assets, talk about what you make per month. And it asks for what your take-home pay is. And if you have a spouse, you're gonna put their take-home pay. If you receive like child support, you're gonna put that amount. Now, if you get a governmental benefit such as SNAP, you'll put that on there, or Social Security, you put it what you're getting per month, or other governmental checks and other income. And if you have any assets like you own a home or a car, you'll put that on there too. And when it gets to the bottom where it says total monthly income or assets, you're just gonna add up everything in the column. Now, if it doesn't apply to you, just put 0. On the next side, on the right-hand side at the bottom, it says monthly expenses. That is, what are your expenses per month? If you're paying rent, you're gonna put, or a mortgage, you're gonna put what you're paying the money. If you get utilities, light, gas, water, you're gonna put that amount in the appropriate column. Now, if you are paying child support, or if you're paying child expenses, you're gonna add that up and put that in the column next to total child expenses. Now, your total food expenses also for the month, you're gonna put that down. Your transportation costs is if you have a car note, car insurance, your gas and your maintenance, you're gonna add all of that. That'll be your transportation costs for the month. Now, if you have a phone, either cell phone or a home phone or both, you're gonna put what you're paying per month. If you're on probation fees, or if you're on parole, having parole fees, you're gonna put that in the column next to probation fees. If you have any medical or health insurance that you require, medical expenses or health insurance, you're gonna put what you're paying per month. Now, if you're paying a minimum monthly credit card, you're gonna place that in the column per month, and then you're gonna add up where it says everything in that column on the stage, total expenses. On the next page, where it says defendant's oath, today's date of the 14th of February of 2023, you're gonna read that. Basically says, I have been advised of my right to representation by counsel in connection with the charge pending against me. I certify that I am without means to employ counsel of my own choosing, and I hereby request the court to appoint counsel for me. And if that is, you're gonna place your name on the line that says defendant signature and today's date, which is February 14th, 2023. At the bottom of this document, you're gonna go to unsworn declaration by defendant. You're gonna fill that out, which says my name, my date of birth is, my address. You're gonna fill that out, and then at the bottom it says, I declare under penalty of perjury that the foregoing is true and correct, executed on the 14th day, executed in Jefferson County, Texas, on the 14th day of the month is February, the year is 2023, and then you'll stop right there. And then the rest of that document will be filled out by the court. Now, if you need any assistance at filling out any of this paperwork, we have our court personnel who will be happy to assist you with filling out the paperwork. Now, if you need any assistance, just simply raise your hand and our court personnel will come by and help assist you at filling out that paperwork. Now, the court is going to go into recess. Now, if you need to use the restroom, there's a restroom in the hallway. If you go out the door, to be straight ahead, the men's restroom is on this side of the, in front of County Court at Law number 3, and the women's restroom is on the other side of the hall in front of the 172nd District Court, which is Judge Templeton. So at this time, the court will be in recess to give you time to fill out the paperwork. And then once we pick that paperwork, then we're going to call you up one at a time, and then we'll try to get through this process as quickly as possible. So at this time, the court will be in recess.